Good afternoon. Before we call the case, wanted to cover a couple of things with the attorneys here. Technology works generally very well, but sometimes there are problems. And if something arises on anybody's end, don't panic. We'll pause and work through it. Mr. Hivner and the IT people from the AOL are very, very good at this and they know what they're doing on the aspect. So if we do have a problem, we'll resolve it and proceed. Mr. Hivner, call the case, please.
City of Athens versus William Stracer.
We'll hear from the appellant.
Van Arian here for the appellant, Your Honor. Would you like me to begin the briefing? Your Honor, my name is Van Arian. I'm here in representing Mr. Bill Stracer in his appeal from the City of Athens judgment against him. There are two issues that we'll be presenting to the court in this case. The first one being the circuit court's denial of Mr. Stracer's request for a jury trial, and also our argument that the ordinance at issue is vague for, is unconstitutional and unenforceable for vagueness. Now, Mr. Stracer is a retired disabled person living by himself. He's lived in his house since 1984. In 2009, he was granted disability status, and in 2009, he went to the City of Athens Codes Enforcement Office 2 different times to discuss with them the carport that he was going to put up. He does not have a garage. And to ask them if he needed a permit. Both times he was assured that he did not need a permit, so he built his carport in 2009. Years later, for its own motives, the City of Athens decided to cite him and took him to city court and ordered him to remove his carport. On appeal to the circuit court, Mr. Stracer requested a jury trial, and that was denied. After that, the court held a bench trial, and the court decided the judgment against Mr. Stracer based on its finding that Mr. Stracer's testimony was not believable, whereas the government official's testimony was believable. Now, we are not here challenging the judge's findings in that case. We are here challenging the fact that the judge was the fact finder in the first place. As the court knows, conclusions of law are reviewed de novo without a presumption of correctness. In this case, the jury issue boils down to a very simple question, whether or not Tennessee Rules of Civil Procedure 38.02 is permissive, or excuse me, 38.03 is permissive or exclusive to the other rules. And as the court knows, 38.03 specifically addresses appeals from municipal and or general sessions courts and sets forth the time that the appellant may, in those cases, request an appeal. The city's stance and the court's ruling is that that is the only rule that applies in those circumstances, whereas 38.02 reads in relevant part, any party may demand a trial by jury of any issue of right by jury by demanding the same in any pleading specified in Rule 7.01. Well, as the court also knows, the Tennessee Supreme Court has established that in these types of appeals, the circuit court is to allow all parties the flexibility of all of the rules of Tennessee Rules of Civil Procedure. And the argument that 38.03 is exclusive simply isn't supported not only by the precedent interpreting rules and interpreting statutes, but also by the language of the rules themselves. 38.02 reads any party may demand a trial. 38.03 does address specifically on appeal from a lower court, but it also uses the term may demand a trial and explains how that is to be done. Nothing in these rules sets forth that they are exclusive of any other rules. The Tennessee Supreme Court and the legislature are well aware of the term notwithstanding other law. Those terms are not set forth here. And in fact, the Tennessee Supreme Court has said, excuse me, circuit courts must regard cases appealed from general sessions courts with great indulgence and must not dismiss the case because of informalities in the general sessions proceedings. That's Ware versus Meharry Medical College, 1995. It continued, it is well established that parties may, without the court's approval, file pleadings, engage in discovery, and take advantage of the procedural flexibility of the Tennessee Rules of Civil Procedure. Now, the Tennessee Supreme Court has also said that the right to a jury trial is superior to the procedural rules. That's Ash versus State ex rel Shriver from 1975. Now, I would stop there and argue that that alone shows that the circuit court abused its discretion in denying Mr. Stracer his request for a jury under Rule 39.02, which grants the court that right, as you all know. The Tennessee Supreme Court also said in Beal versus Doe v. Reed, when in doubt, courts should grant the right to a jury trial rather than risk denial of this substantive constitutionally protected right. The Supreme Court also said that if statutes, and it was discussing statutes in this particular case, if statutes seem to conflict with each other, if there is a construction that allows those statutes to not conflict, that the court must adopt that construction. And in later case, in Thomas v. Oldfield, 2009, it confirmed that that rule does apply to rules of procedure as well. Leaving this point or this particular issue and moving on to the other, I'll conclude with, Your Honors, we're left with a case where a citizen is cited by a government entity. A government paid judge denies him a right to a jury trial and then rules and bases his judgment on the fact that he doesn't believe the citizen. This is a situation where a citizen is losing his right to have a carport in front of his house, and he had absolutely no input from anyone other than government officials at this point. Now, moving
Counsel,
on to the
Counsel,
yes.
when was the request for jury made?
That was made it was made when in March of 2019, March 22, I believe, which was when the initial answer to the city's citation was filed with the court. And that was several months before the court ruled on this issue. It had another hearing on it and ruled on it, and then we had the trial later, the bench trial.
When was the court, when was the case appealed to this court in relation to the request for the jury demand?
After the bench trial, Your Honor.
And that bench trial was in what, the city court?
That was in circuit court, Your Honor.
Circuit court. Okay.
Yes, there was a city court trial that was appealed timely, and then there was the circuit court trial, bench trial, and that's what we're appealing here.
Okay. Okay. Thank you.
Was the appeal from, excuse me, was the appeal from city court in July of 2017?
That sounds right, Your Honor.
And the request for a jury was in March of 2019, correct?
Correct.
And that was in connection with an answer and perhaps a counterclaim that had been filed?
This was in connection, this was on the pleading, the first pleading filed in circuit court by Mr. Stracer. And that was the answer to the city's complaints, or the city citation. And there were also new factual allegations supporting counterclaims and defenses, specifically waiver.
Thank you.
Now, moving on to the vagueness argument, as the court knows, a law is void for vagueness if it fails to give a person of ordinary intelligence a reasonable opportunity to know what conduct is prohibited or to provide sufficient standards for enforcement. That's Monsieur versus Board of Professional Responsibility, Tennessee Supreme Court 2013. Now, in this case, the official from Athens who was responsible for enforcing the ordinance and took the measurements actually testified that he did not and could not accurately establish the location of the right-of-way line, which was where he was supposed to be beginning his 30-foot setback. The entire section of the ordinance that is at issue here reads, the minimum depth of the front yard shall be 30 feet. That's it. Now, the definitions in the ordinance actually do describe the terms, the term right-of-way, but it also uses property line and road. And the definition for right-of-way is an area of land that is legally dedicated to the public use for a public street. The street pavement curbs, shoulders, and sidewalks are located in the right-of-way and generally do not represent the boundary of the right-of-way line. Again, Your Honor, Your Honors, the statute or the ordinance uses the terms property line, road, and right-of-way. And the very person who is responsible for enforcement testified that he could not establish where the right-of-way line was. That's all I have, Your Honor.
I do have one other question, please. Was there a recorded plat that established where the right-of-way is in connection with this case?
There is a plat that establishes the roadways, that establishes the neighborhood, Your Honor. However, the Supreme Court, Tennessee Supreme Court in, excuse me. The Tennessee Supreme Court established that the presumption is that the center of the street is the property line for any given platted lot, and that is true regardless of any easements that the city may have. In this case, there's nothing that has rebutted, that I'm aware of, that has rebutted the idea that Mr. Stracer owns to the center of the street, as does his neighbor across the street, despite the fact that there's an easement for the road and other items that the city puts in. If measured from the center of the street, then I mean, that would be one option. That would be the property line, but it's not the right-of-way line and it's not the edge of the road. In fact, they measured from the edge of the road. They did not measure the width of the street or establish where the center line was.
Thank you.
Yeah, Phoebe, you have your time for rebuttal. We'll hear from the appellee. You need to unmute.
Apology. Good afternoon. My name is Chris True. I practice in Athens. I'm a member of the McMinn County Bar, where Athens is located. The city of Athens obviously is the appellee in this case. Is our position the trial judge made no errors, and I'll address the arguments made by Mr. Stracer and also try to answer some of the questions the court has already asked. Again, as Mr. Iron has pointed out to the court, they're not contesting the judge's finding that there was a violation. They are alleging that the judge erred with certain pretrial motions, one of which was a motion for a jury trial. This case started in Athens City Court in 2017. There was a ruling adverse in Athens City Court to Mr. Stracer. There was a timely appeal made to the circuit court, but in that appeal notice, there was not a demand for a jury. The applicable rule is Rule 38.03 of the Tennessee Rules of Civil Procedure, and the court Your Honors may be aware of it, but it's rather short, it's specific, there's no debate about what it says. It says in cases removed by appeal or otherwise to the Chancery or Circuit Court, any party may demand a trial by jury of any issue triable by jury by filing a written demand for jury trial within 10 days after the papers are filed with the clerk. There was no jury demand made within 10 days of when the appeal was taken. It's our position there was not a timely demand for a jury for several reasons. Again, Mr. Stracer had an attorney when the case was appealed from Athens City Court. Mr. Van Arian subsequently substituted his attorney, and he was involved in the case for a number of years and ultimately tried the case. Of importance on this issue of whether it was timely made, as Judge Frierson has already pointed out and noted, the demand for the jury was 2 years after the case was appealed to circuit court. And of importance, the case had been set for trial on 2 occasions. It was set for trial, let me look at my notes. It was set for trial on January the 26th of 2018, non-jury. And before that trial setting, there was no motion for a jury trial. After that case, the case was removed from the docket for January 26th. There was no motion filed for a new jury trial. The case was reset on April the 22nd of 2019 by an agreed order signed by myself for the city of Athens and signed by Attorney Van Arian for Mr. Stracer, setting the case non-jury trial for April the 22nd, 2019. So that's the second or third opportunity there was to ask for a jury trial, and it wasn't made. And I think it's significant that counsel for Mr. Stracer signed an order setting the case for trial non-jury and did not raise the issue for considerable more time when he ultimately did file some pleadings, and in those pleadings asked for a jury trial for the first time. So the demand was not timely made. And then the second part of our argument is that it was waived. The jury trial was waived. Mr. Arian did not mention another rule which he cited in his brief and made repeated references to the trial judge, and that is Rule 39.02 of the Tennessee Rules of Civil Procedure. That gives the trial judge the discretion to allow a jury trial when a timely demand was not made. But again, in this case, it was not timely made. The judge properly exercised his discretion because, again, it had been waived so many times by the previous trial settings and waived when Mr. Arian signed an order setting the case for a non-jury trial. So the rules were not followed. There was no timely demand made for a jury trial, and waiver is an issue for this court. I think waiver is certainly applicable here, and part of the reasoning of the trial judge in not granting or exercising his discretion to allow him a jury trial by looking at the record and seeing this case has already been set twice, once with your signature on it for non-jury, and then years later you come up with the idea you want a jury trial. So we asked the court to affirm the decision below that the trial judge was correct in denying a jury trial. The other issue raised by Mr. Stracer is that the ordinance is vague and therefore unconstitutional and can't be enforced. The ordinance, all of the ordinances that are relevant to this situation are in the record. They were not initially included, but when I discovered that the clerk inadvertently did not place them in the record, we had those sent up separately. But the charging ordinance was section 3.04.03E, which says that the minimum depth of the front yard shall be 30 feet. What is vague or unclear about that? A person of common intelligence can easily read that. The minimum depth of the front yard shall be 30 feet. That tells you you've got to have a front yard of 30 feet. So next you move to the definition of front yard, which is the required open space unoccupied by buildings between the road or street right-of-way line and the principal building. There's nothing vague, there's nothing unclear about that. You measure from the street or the road right-of-way 30 feet, and you can't have a building within that area. I never have really understood the argument at trial. The argument was that in the definition of front yard, you either measure from the road or street, or you measure from the right-of-way line. Now, the trial judge didn't accept that argument at all, recognizing that road or street modifies right-of-way line, so you're measuring from the right-of-way line. And those are the two applicable ordinances. They are not vague. A person of common, ordinary intelligence could interpret those. You measure from the right-of-way line. If you need assistance with determining where the right-of-way line is, you can ask for a building permit, which this gentleman never asked for, by the way. He was required to ask for a building permit because he's erecting a building, and he didn't ask for the building permit. If he had, someone would have gone out there, this issue might have been addressed then, and he would have placed his carport in the proper area, but he didn't ask for a building permit. He didn't even make any attempt to make any measurements because his testimony was, they told me I didn't have to do anything other than put my carport somewhere within the boundary lines of my property. So he didn't ask for help from the city with respect to determining where that 30-foot would exist. He didn't hire a surveyor, which he could have done to establish where the right-of-way was at. So again, there's nothing vague, and the ordinances should stand. They're not unconstitutional. Of importance, I think, and it goes to one of the questions Judge Frierson had, we filed of record, put in the record, the plat of this subdivision. It may have been 50 lots, I don't recall, but we put the old plat in, and the old plat had this area, had Sunview Drive on it, and then had it by lots. The deed, we also put that in. They didn't. We put his deed in because his deed says you are conveyed lot 3 in this particular subdivision, which is a record and plat book, whatever it may have been. And again, we put a copy of the plat in the record. And then lot 3 is shown on that plat with its property line the same as the end of the right-of-way line. The right-of-way that was dedicated to the city of Athens when that plat was recorded was 40 feet. And within that 40 foot, of course, they eventually placed a road. But of importance, the property line in this case is the same as the right-of-way line. And the measurements were taken by the city officials from the edge of the street because we'll go back since we've been talking about common sense. Common sense tells you that the street is somewhere within the right-of-way. The right-of-way may have actually extended further into his property, but the measurement at trial was from the street edge. He constructed his carport, I believe, 17 feet from the street, which is in violation of the ordinance, and that's why the judge found the violation. The judge read all the ordinances and did not find there was anything that somebody couldn't understand clearly, and we asked the court to affirm the judge's pretrial ruling, which was made the day of the hearing, because this Judge Frierson has pointed out, this case has been in the circuit court for almost 3 years, and the motion to find the ordinance unconstitutional was filed, I think, 3 weeks before the trial. The motion had to be heard the day of the trial, and it was, and the trial judge was correct in his ruling. So we asked the court to affirm the decision below, deny the relief requested by Mr. Stracer, and we think that's the proper ruling for this court in this case, and I thank you.
Thank you. We'll hear from the appellant in rebuttal. Counsel, I think you muted you need to unmute. Counsel, you need to unmute your mic. Thank you.
Can you hear me now? Thank you. Counsel for the city stated that Mr. Stracer should have asked for a building permit. And in fact, the testimony from Mr. Stracer was that in 2009, he went to the building permits office and twice asked them if he needed a building permit and talked to them about it. They denied that this ever happened. And there was proof that there was actually a meeting, at least one meeting, and the judge's ruling, the court's ruling, without a jury, was that he didn't believe Mr. Stracer and he did believe the city. So this again goes back to our argument that, and also everything that counsel has said about the jury trial issue, none of it changes the fact that it is a simple question. Is 38.03 the exclusive rule on these types of appeals or not? Is it permissive?
Counsel, let me ask you about that. Counsel, let me interrupt you a second. Are you saying that the trial court just refused to exercise its discretion, or exercised its discretion and held that it was just untimely, and so I'm not going to grant it?
To both, Your Honor. Actually, it refused to exercise its discretion under Rule 39, which grants it that discretion, even if, and Rule 39 specifically says if the demand was untimely. Whereas in this case, we're saying that the demand was timely, but we also asked the judge, if you are right that the demand was untimely, would you please exercise your discretion? And the court refused that. And again, based on what the Supreme Court says about, has established about the right to a jury, we believe that was an abuse of discretion. However, our primary point is that 38.02 and 38.03 can be read to both be true. They simply established two different times that a jury demand can be made, and the jury demand was made upon the first filing of Mr. Stracer's answer and defenses. Again, this leaves us with a situation, a classic situation, as to why juries were created in the first place. They're supposed to be a check on government, if for no other reason than to keep the citizens satisfied that the government isn't doing anything it wants with no checks. This is a perfect case where a judge decided that there was no right to a jury trial, even though the rules are supposed to be very permissive. The demand was made timely under at least one rule, and then he decided the case based on not believing the citizen and believing the government employees. If this kind of case is going to be is going to happen regularly, it could easily lead to citizens not trusting the government court systems. I think this is a very important issue, and juries ought to be allowed very permissively.
Anything else?
That's all I have, Your Honor.
All right. Thanks to counsel for both sides. We appreciate your arguments and your briefs on this matter. If you would, Mr. Hivner, recess court until 3:30 this afternoon.